Finance Committee will come to order. Before we begin, I'd like to ask that a statement from New Jersey First Lady Tammy Murphy, who's been a leader on women's reproductive health care, be entered into the record. Today, the Finance Committee meets to discuss the growing threat to reproductive health care in America. The threat is compounded by the failure of a growing number of states to adhere to the letter and spirit of the law that is in our committee's jurisdiction that protects the rights of women to receive emergency reproductive care. As a result of Republicans' years-long crusade on reproductive freedoms, women in America are faced with the prospect of losing yet another pillar of reproductive care, the Emergency Medical Treatment and Active Labor Act. With the help of Senate Republicans, Donald Trump confirmed 3 far-right justices to the Supreme Court. Each of them swore up and down that Roe was settled law, that there wasn't any threat to any facet of reproductive freedom, no risk of any domino effect. Each of these judges, through those pledges they took under Senate oath, into the trash and gutted Roe at the very first opportunity. The consequences of that decision, while predictable, are gut-wrenching. Women are miscarrying, suffering life-threatening blood loss, losing their ability to bear future children, or dying because they were denied the emergency medical care that they needed. Doctors are being targeted or forced to relocate to states where they can practice basic medicine without fear of a legal witch hunt. And let's not forget that earlier this year, when Alabama State Supreme Court handed down a ruling that effectively banned IVF in that state. All of this was made possible by abortion bans that went into effect under Donald Trump after his Supreme Court gutted the Roe decision. So that brings us to EMTALA, over which this committee has black-letter law jurisdiction. This law guarantees that anyone entering a hospital that receives Medicare funding, which is most hospitals in America, will get the emergency health care they need, reproductive or otherwise. A woman may come into the emergency room with an ectopic pregnancy or bleeding out from a miscarriage, and EMTALA is what ensures that she gets the necessary care. It also protects the doctor, who has a sworn oath to provide that care, even in states where an abortion ban is in effect. Some states that have passed abortion bans into law claim that they contain exceptions for emergency care if a woman's life is at risk. In reality, these exceptions, so-called, are forcing doctors to play lawyer and lawyers to play doctor. Providers are scrambling to make impossible decisions between providing critical care or a potential jail sentence, and hospital lawyers are being forced to make medical decisions they have no business making. While providers and lawyers struggle to interpret a patchwork of state and federal laws that dictate whether a woman should live or die in America, patients are going without the care that they urgently need. These exceptions, in my view, aren't worth the paper they're written on. In June, the Supreme Court heard arguments on Idaho's abortion ban, which denies women the right to receive emergency reproductive care as guaranteed under the EMTALA law. The Supreme Court didn't rule on whether or not it agreed with Idaho's request to defy federal law, but dismissed the case on legal technicalities. That means, just like they did with the mifepristone case it ruled on earlier this year, the Supreme Court is effectively kicking the can down the road, biding its time until the far right can cherry pick another case that will clear the necessary judicial hurdles. When they find it, they'll bulldoze existing law and set a new precedent that allows states like Idaho to let women die waiting for care rather than giving them the treatment they need. Now, my own view is this was the Republican strategy from the beginning. Overturn Roe, tie women's bodies up in legal battles in courts across the country, leave women and doctors questioning if they're going to be jailed for seeking or providing needed care. Now, I'm sure today we're going to hear an argument that there is no threat to EMTALA, that it's settled law. Well, Republicans said the same thing about the Roe case. And look at where America is today. My view is the American people aren't going for it. Medical experts are saying there's no question women are dying in emergency rooms because they're being denied the care they need, despite EMTALA, under the jurisdiction of this committee, still being the law of the land. Meanwhile, as recently as 2 weeks ago, Donald Trump is still bragging about having successfully overturned this mainstay of women's health care. His running mate, J.D. Vance, has thrown his support behind some of the most extreme positions on this issue, like a national abortion ban and uterus surveillance, tracking a woman's medical records to determine if she'd receive abortion care. And Project 2025, which appears to now be the guiding doctrine of some in the Republican Party, promises to reverse EMTALA's protections for emergency abortion care. So I'll close by thanking our witnesses. I think we're going to have a real debate here this morning. It's high time. Dr. Amelia Hunsberger is here, an OBGYN from my home state in Eugene, was facing threats and forced to relocate from Idaho after the Trump abortion ban went into effect. Caitlin Joshua of Louisiana experienced a horrific miscarriage after she was denied critical medical care at 2 different hospitals in her home state. Michelle Goodwin, a legal expert who's devoted her career to protecting women, is going to tell us exactly how the repeal of Roe has affected patients and providers like Dr. Hunsberger and Ms. Joshua. So, the overturn of Roe laid the groundwork for states to break federal laws that have been on the books for decades so they can control women's reproductive care. And frankly, on a personal note, I can't believe that all these years later, we're still debating whether women ought to be able to make their own health care decisions. It was quite some time ago when I had the first hearings on mifepristone. So we're still litigating these issues, and the Supreme Court may be kicking the can down the road on EMTALA and mifepristone, but I just want everybody to know on our watch, this committee will never look the other way. This is real. It's happening right in front of us, and I want everybody to know we're going to stand up for the rights of women. Senator Crapo.
Thank you, Mr. Chairman. Before I begin my opening statement, let me address the fact that the Senate Finance Committee has never had a non-sitting president's name in its hearing title, which should tell us all we need to know about the reason for this hearing. Since its earliest origins, the practice of medicine has been grounded in the Hippocratic Oath, often colloquially distilled into first do no harm. The code of medical ethics is far more complex and rooted in compassion and humility. Across the country, thousands of providers commit to upholding these principles to treat patients and all lives with profound respect. When a provider serves a pregnant woman, this philosophy applies to 2 lives. Mrs. Joshua, your experience is unacceptable. Fear and ignorance should never drive clinical decision-making. Let me be perfectly clear. Seeking care for a miscarriage is not an abortion. Similarly, to the families and loved ones of Amber Thurman and Candy Miller, you have my deepest sympathies. Their deaths were preventable, and it is incumbent on us all to ensure that no lives are lost under similar circumstances. The subject of abortion touches our moral and ethical core. The conversation demands respect, and rhetoric must be accurate. Anything short risks sowing confusion with potentially devastating consequences. Unfortunately, as demonstrated by the overtly partisan nature of the title of this hearing, it appears the purpose of today's hearing is to score political points against a former president. In 2022, the Supreme Court appropriately ruled that abortion policy should be determined by states, and importantly, their residents. That's what the decision was. Since that time, a number of states have passed laws that reflect their values either through legislatures or ballot initiatives. Unsurprisingly, Idaho and Oregon have taken different approaches, as they do on many issues. But I will say, Mr. Chairman, Idaho law does not break federal law. However, regardless of divergent views on abortion, everyone on this dais agrees that life is precious. Women and children, including unborn children, deserve high-quality health care from professionals who are equipped to both share in the joy of pregnancy and react to unseen complications. As a board-certified OBGYN, Dr. Francis is here to discuss her work educating physicians on life-affirming care. As an accomplished attorney, Ms. Hacker will share her deep understanding of accuracy on state abortion laws. Together, their testimony will seek to clarify the accurate facts about this debate. Abortion is unlike any other policy issue. Positions are shaped by our experiences, tied to our ethical philosophies, and rarely simplistic. As we move forward with our conversation today, I encourage all my colleagues to remember the Hippocratic Oath and to approach this discussion with compassion and humility. And thank you, Mr. Chairman.
Thank you, Senator Crapo. So let me give a brief introduction for our witnesses, and then we'll go to your testimony. Caitlin Joshua is here. She's a wife and a mom who lives in Baton Rouge, Louisiana. She and her husband found themselves trying to navigate a healthcare crisis in the post-Dobbs, Louisiana area when she was denied care at 2 hospitals in her area while experiencing a miscarriage at 11 weeks pregnant. And it sure seems brave of you to be here, Ms. Joshua. Thank you for doing that. Amelia Hunsberger is a board-certified OBGYN who practiced in rural Idaho for a decade. In addition to her medical practice, she was involved with a number of state-level organizations, including the Idaho chapter of the American College of Obstetricians and Gynecologists, the Idaho Maternal Mortality Review Committee, and the Idaho Perinatal Project. She chose to relocate to my home state of Oregon to continuing practicing medicine in 2023 after the overturning of Roe. We are very glad you're here. Dr. Christina Francis is a board-certified OBGYN who currently practices in Fort Wayne, Indiana. She is CEO of the American Association of Pro-Life Obstetricians and Gynecologists and a board member of Indiana Right to Life. Welcome. Heather Hacker is a partner at Hacker Stephens LLP in Austin, Texas. She's represented organizations such as Texas Right to Life relating to significant constitutional issues. Previously, she served as Assistant Solicitor General in the Texas Attorney General's office under Texas Attorney General Ken Paxton. Welcome. Michelle Goodwin is the Linda D. and Timothy J. O'Neill Professor of Constitutional Law and Global Health Policy at the Georgetown University School of Law. She is one of the most cited health law scholars in the world, focusing on reproductive health and justice, and the author of the book, Policing the Womb, Invisible Women, and the Criminalization of Motherhood. So I want to thank all of our witnesses. We are going to make your prepared statements a part of the record in their entirety, and if you could take your 5 minutes or so to discuss the state of reproductive health care in America, we'll appreciate it, and you'll each have 5 minutes for oral testimony. Let's begin with you, Ms. Joshua.
Good morning. Thank you, Chairman Wyden, for having me, and Ranking Member Crapo, and members of the Senate Finance Committee for having me here today. My name is Caitlin Joshua, and I'm from Louisiana. I'm here to talk about my own experience under extreme abortion bans in my home state soon after the Supreme Court eliminated the federal right to abortion care more than 2 years ago, and the problem these laws caused me and continue to cause other pregnant Louisianians and their families. You see, I was turned away without care twice from 2 different emergency rooms in Louisiana while experiencing a painful and potentially dangerous miscarriage. This was 2 summers ago. My husband Landon and I were already parents to a curious and happy 4-year-old daughter when we found out I was pregnant again. We were thrilled. At least to us, this was the perfect time to add a second baby. But this time, Louisiana's new abortion ban affected my pregnancy from the very start. When I called to schedule my first prenatal appointment, I was told I would have to wait until I was 12 weeks pregnant, a month longer than my first pregnancy. I asked, if this was because of the Louisiana abortion ban, and the young lady was very candid. She said yes. Because of the abortion ban, prenatal appointments were purposely scheduled weeks later than normal, delayed further into pregnancy when miscarriages are less common, to avoid potential legal and criminal liability for medical providers. Practically overnight, these laws were already compromising health care for all pregnant patients. Aside from experiencing some mild cramping and spotting, my second pregnancy was going along okay until around 11 weeks, just 1 week shy of that first prenatal appointment. I started bleeding while also experiencing pain worse than childbirth. My husband was at work at the time, so I drove myself to the emergency room. There, the medical team evaluated me and told me that my fetus had completely stopped growing. I realized I was having a miscarriage, but because of the state's abortion ban, the healthcare team wouldn't even say the word. They sent me home telling me that they would pray for me. The next day, the bleeding and pain got worse. I did not want to go back to the same hospital that I had been turned away the day before, so I met my mom and husband at a different hospital. I was losing so much blood at this time, even the security guard knew to put me in a wheelchair. The standard treatment for a miscarriage, what I was experiencing, is exactly the same treatment as abortion care, to empty the uterus by prescribing pills or a procedure called a D&C. It is an abortion. Yet in this second hospital, the staff told me we're not doing that right now and told me to go home and wait. Ultimately, it took me weeks for me to pass my pregnancy at home on my own without medical care, and I was absolutely terrified. This experience has made me see and realize how Black women like me die needlessly in and around childbirth. Since telling my story, I've received hundreds of letters from women across Louisiana who have had similar experiences, and we know routine and potentially life-saving medical care is being in denied states across the country. And I've met so many other women who are also suffering because of abortion bans like others in Louisiana. 22 states have banned all or most abortions, and several states have criminal penalties for healthcare providers. As a result, doctors and other healthcare providers are afraid to treat patients who are miscarrying. And that's why women like me are being denied the dignity of basic, essential, time-sensitive healthcare that saves our lives, abortion care. Capable and caring physicians simply cannot practice medicine based on their training and expertise, and of course, the Hippocratic Oath. We're simply asking for, yet still being denied, the most basic level of maternal health care. Sharing my story is not fun, nor is it easy. I don't like being away from home. I have 2 children now, and part of me would like to forget the weeks of trauma I endured. But I know that I have to speak out. I owe it to those women who wrote to me, who have met in person, for women who look like me, and for women who don't. This is certainly an attack and an affront to our most basic fundamental rights: life, liberty, health, happiness, self-determination. This is government and political interference in private healthcare decisions. How is that okay in a freedom-loving country in 2024? Again, thank you for having me today.
Thank you, Ms. Joshua. I know you're going to get some questions in a moment, but my own view is you're speaking for many, many people, and we appreciate your being here. Dr. Hunsberger.
Chairman Wyden, Ranking Member Crapo, and members of the committee, thank you for having me. My name is Dr. Amelia Hunsberger, and I'm a board-certified OBGYN. I currently live and work in Oregon, but previously practiced medicine in rural Idaho for more than a decade. Prior to leaving Idaho, I was the Idaho Section Chair of ACOG. I volunteered on the Idaho Maternal Mortality Review Committee, and I was on the advisory board of the Idaho Perinatal Project, a committee that worked to advance health of moms and babies. I am here testifying in my personal capacity. I am a generalist OBGYN. I provide PAP screening, STI testing and treatment, and prenatal care. I prescribe contraception, and I treat infertility. I deliver babies, and I provide abortion care. I grew up in rural Washington, and I met my husband, who also grew up in a small town, during medical school. For 11 years, we practiced medicine in Sandpoint, a town of 9,000 in Idaho. During that time, it was my privilege to serve my community. All people deserve high-quality health care, no matter where they live. Idaho has enacted some of the strictest abortion restrictions in the country, without exceptions, to allow doctors to act to preserve a pregnant patient's health, not even to prevent harm to organs or function, like fertility, unless an abortion is necessary to prevent death. The lawmakers who created these bills knew it. The cruelty was built in. The fallout of these strict abortion laws was never unanticipated. Once the total abortion ban went into effect post-Dobbs, it no longer felt like a safe place to practice medicine. There was widespread confusion and lack of consensus about Idaho's abortion laws among the medical and legal community. The risk of criminal prosecution and civil penalties immediately felt very real for my husband, who's an emergency medicine physician, and for me as an OBGYN. Keep in mind that delaying or not providing standard evidence-based medical care also puts physicians like us at risk for medical malpractice charges. These laws forced us to consider what would happen to our children if both of their parents went to jail. Many doctors in Idaho, like me, tried to raise awareness of the harm from the abortion bans. I naively thought that if people just understood the laws, they would be fixed. As a result of talking publicly about abortion, we began to fear for the safety of our family. Ultimately, we decided to leave. Just over a year ago, we packed our things and moved to Oregon, taking our children away from the only place that they had ever called home. To call the situation traumatic would be an understatement, and it was nothing compared to what the patients in my community experienced. A week after we gave our notice, hospital administrators decided to close the labor and delivery unit at our critical access hospital. The hospital cited the abortion laws as one factor in the decision. All 3 of my OBGYN partners left, each going to a state without abortion restrictions. Many of my patients in Sandpoint traveled long distances to receive care. Many struggled with finances. Some did not have reliable transportation, and many experienced food scarcity. During my last year in Idaho, I took care of 2 pregnant patients who were living in their cars and a 3rd who lived in a tent. When the labor and delivery unit at the hospital closed, the impact on the community was staggering, but it was most profound on already vulnerable groups. With the closure, not just pregnancy and delivery care were impacted, patients no longer have local access to gynecologic care either. I am not the only physician to leave a state because abortion bans have made it unsafe to practice medicine. 22% of the OBGYNs have left Idaho since the bans went into effect. 55% of maternal fetal medicine doctors, the high-risk pregnancy experts, have left Idaho. 55% are gone. So far, 3 labor and delivery units have closed. Abortion is safe. Abortion is healthcare. Abortion is at times necessary to protect patients' health and their lives. What is unsafe is allowing the government to make healthcare decisions for patients and preventing doctors from treating patients who need care. Abortion bans make pregnancy more dangerous and exacerbate our country's maternal mortality crisis. Most maternal deaths are preventable. At no point in pregnancy is any politician more qualified to make healthcare decisions than a patient and their doctor. Government interference in healthcare must stop. Thank you for your time.
Thank you very much, Doctor. You're going to get some questions in a minute. That was very, very important to hear because I think doctors are getting threatened all over America, just as you suggest. Dr. Francis.
Chairman Wyden, Ranking Member Crapo, and members of the committee, thank you for the opportunity to be here today. I also have with me 4 physicians who used to perform elective induced abortions. They stopped doing them because they recognized that induced abortions were actually harming their patients and were not necessary for women's health. The title of this hearing is an attempt to redirect the public's attention away from the true danger to women's health. Unregulated and dangerous abortions that not only ended the lives of over 1 million human beings last year in the United States alone, but also are harming and killing women. The only cause of confusion is dangerous rhetoric. This rhetoric falsely tells women they could be prosecuted if they go to the hospital for complications after an abortion, when in fact pro-life laws hold women harmless. This rhetoric falsely tells doctors that DNCs are banned when DNCs for every indication other than to induce an elective abortion are completely legal. A DNC could have been given to Ms. Joshua and should have, and I am so sorry, Ms. Joshua, for what you experienced. This rhetoric falsely tells doctors they can't provide miscarriage care or treat ectopic pregnancy when they actually can and should. It falsely tells doctors they can't act until women are actively dying when no state laws require this. And it falsely tells women that abortion drugs are safer than Tylenol when we have clear evidence they are more dangerous than surgical abortions and can be deadly. I am a board-certified OBGYN who has had the privilege of caring for women for nearly 2 decades. For the last 8 years, I have worked as an OB hospitalist, taking care of women in the hospital with both high and low-risk pregnancies. I've delivered thousands of babies in my career, along with treating women experiencing miscarriage, ectopic pregnancy, and post-abortion complications. My entire career, I have practiced in a way that is completely consistent with current pro-life protections in states across the country, including my home state of Indiana. and I have not had any patients die because of withholding treatment. Exploiting the tragic deaths of women like Amber Thurman and Candy Miller to win a political battle is disgusting, and a political game it is. Where was the outrage over the death of Alana Dixon, a 24-year-old mother in Nevada who died in September 2022 from a septic abortion less than a week after taking the same abortion drugs that Amber and Candy did? Could it be because Nevada doesn't have a pro-life law that abortion proponents could try to blame for her death? There is a common denominator for all three of these women: high-risk abortion drugs with no ongoing care from a physician. This is the cause of their deaths and that of their unborn children. In fact, infection like what Amber and Alana experienced is the leading cause of death from the abortion drug mifepristone. APLOG, the medical organization I lead, has been sounding the alarm on these risks for years, while the abortion industry falsely claimed these drugs are safe and the FDA continued to remove common sense safeguards from them. And now that it is obvious that our warnings were true, the abortion industry and its allies are blaming these deaths on pro-life laws. These laws prevent elective induced abortions, something 76 to 93% of OBGYNs do not do as part of their practice. The CDC definition of induced abortion notes that it excludes management of intrauterine fetal death, early pregnancy failure or loss, ectopic pregnancy, or retained products of conception. No law in the country prevents physicians from doing any procedure for these conditions or if needed to preserve the life of a woman. Let me be clear. Pro-abortion media, politicians, and activists need to stop putting women's lives in danger by creating unnecessary confusion about laws that in reality make clear exceptions for physicians like me to treat women experiencing pregnancy complications. Start telling the truth. Women deserve better than inaccurate information and fear-mongering. Regardless of our feelings about induced abortion, we should all want physicians and patients to receive accurate information about their state laws. APLOG has filled the gaping hole left by other medical organizations in educating physicians to ensure they know they can continue to provide their patients with excellent health care. Women are not dying because of pro-life laws. They are dying because of unregulated abortion and a lack of follow-up care demanded by abortion activists and their allies. It is a travesty, and it must stop. Thank you.
Thank you. Ms. Hacker.
Chairman Wyden, Ranking Member Crapo, and members of the committee. Thank you for the opportunity to present testimony on this topic based on my expertise as an attorney and a practicing litigator. There's a lot of misinformation and confusion surrounding the law regarding medical treatment of pregnant women and abortion restrictions. It's critical that policymakers, public advocates, and the legal profession correct legal misinformation being spread through the media to ensure that pregnant women are not hindered from receiving timely medical care. I am grateful to the committee for providing me this opportunity to explain what the law says about this important issue, which is so critical to women's health. Regardless of the state, laws restricting abortion do not prevent physicians from treating ectopic pregnancies, miscarriages, or women suffering life-threatening complications, including complications from abortion. To the extent that this has been reported by the media, it is incorrect. To the extent that doctors have claimed their hands are tied in treating patients in these circumstances, they are mistaken. And to the extent that women believe that any law will prevent them from receiving life-saving care, they are sadly misinformed. The evidence demonstrating the truth of these statements is not partisan. It comes from the text of the laws themselves. In general, the legal definition of abortion is the purposeful termination of a pregnancy with the intent to cause the death of the unborn child. Under that definition, which only varies slightly from state to state, procedures to treat ectopic pregnancy or miscarriage are not abortions because they are not procedures performed with the intent to cause the death of the unborn child. In a case of a miscarriage, the unborn child has already passed away or will soon. In the case of an ectopic pregnancy, the pregnancy cannot grow normally outside the uterus, and permitting it to continue will cause serious injury to the mother. For the same reason, prohibitions on abortion do not prevent a physician from caring for a patient suffering from complications from an abortion. Access to contraception is not affected by abortion statutes because the purpose of contraception is to prevent pregnancy, not to terminate a pregnancy or cause the death of an unborn child. And even though the legal definition of abortion does not include treatment for miscarriage, ectopic pregnancies, and contraception, most states go even farther and expressly clarify this in their laws. While Dobbs did change the law in that it permitted states to prohibit abortion or limit its pre-viability if they chose to, it did not criminalize anything. Dobbs also did nothing to change how exceptions to abortion laws apply, which typically allow abortions to be performed where, in the reasonable medical judgment of the doctor, an abortion is necessary to prevent the death or serious harm to the mother. Those exceptions were common many years before Roe. They were common before Dobbs, and they do not apply any differently now post-Dobbs. The reasonable medical judgment standard used by these exceptions has applied broadly for decades. It's the same standard by which all medical decisions are judged under traditional theories of tort law. Physicians have been familiar with exercising reasonable judgment in treating patients within the parameters of the law for decades in all contexts of medical practice, and not just abortion. In the context of abortion, though, the pre-Dobbs Supreme Court approved this language many times since Roe, essentially requiring that all abortion laws have such an exception in order to satisfy the undue burden standard which applied under Roe. In other words, in virtually every state with an abortion restriction, physicians have already had to comply with this same standard for decades. Physicians are also not alone in determining whether their medical judgment is reasonable. As the standard originates in tort law, it looks to what the standard of care is. If a physician's judgment in a particular situation is consistent with guidelines from medical organizations or from state medical boards, for example, it is certainly reasonable. We also know that physicians are exercising their judgment under these exceptions and have performed abortions in case of medical need. For example, since Dobbs, at least 113 abortions have been performed in Texas under the medical need exception. And I have located 0 reported cases anywhere in the country involving the prosecution of a doctor who performed an abortion he determined was necessary to protect the life of the mother in his reasonable medical judgment, whether pre or post-Dobbs. Additionally, there's nothing in these statutes that requires physicians to wait until harm is imminent to provide treatment, and multiple state Supreme Courts have affirmed that to be the case. If there is confusion as to what treatment is available for pregnant women in these states, it is not because of what the laws say. Thank you.
Thank you, Ms. Hacker. Ms. Goodwin.
Committee Chairman Wyden, Committee Ranking Member Crapo, and distinguished members of the Senate Finance Committee, thank you very much for inviting me to participate in today's hearing. My name is Michelle Gratcher Goodwin. I am the Linda D. and Timothy J. O'Neill Professor of Constitutional Law and Global Health Policy at Georgetown, where I'm also the co-faculty director of the O'Neill Institute. Over the past 25 years, my writings about urgent matters of national and global health, including reproductive health, rights, and justice, have been published in books, elite law reviews, peer-reviewed medical journals, and in newspapers of record, and in amicus briefs submitted to federal courts, including the United States Supreme Court. This hearing is aptly framed as the legal, social, and moral chaos unleashed since the United States Supreme Court's Dobbs decision has brought about a torrent of pandemonium, fomenting havoc for medical providers and hospitals. It has exacerbated and caused the closure of clinics that provided the only healthcare services for tens and even hundreds of miles for economically disenfranchised women and families. These closures, which were foreseeable, placed the lives of women and girls at risks. Undeniably, the zealotry to overturn Roe and the sweeping legislative enactments of abortion bans show a tremendous disregard for the health and safety of women and girls. The chaos unleashed on women's basic health care is most critically exposed in the shifting landscape on emergency medical treatments. In 1986, Congress enacted the Emergency Medical Treatment and Labor Act, known as EMTALA, to, quote, to ensure public access to emergency services regardless of ability to pay. EMTALA was a bold congressional effort to ensure care for pregnant women as well as all persons in need of emergency care when they are most vulnerable. Explicitly, labor is framed within the title of the law. The purpose of this law is to ensure that patients in emergency situations are not turned away, sent off, or refused treatment. And I want to take a moment to acknowledge Ms. Joshua and the horrific experience that she had, as well as so many others, Kate Cox, Brittany Watts, Amanda Zarowski, and so many others. The legacy preceding EMTALA's enactment involved patient dumping, a term used to describe the denial of emergency care to individuals because of their insurance status or lack thereof, poverty, or even their race and their gender status. Some patients died as a result of being dumped or their conditions worsened. This legacy of patient dumping has race, sex, and poverty-based discrimination at its foundations. Black patients were routinely turned away from medical clinics and hospitals that refused to admit them, and we see that in real time today. Allowed after the Dobbs decision, pushed forward by states' legislatures. Horrifically, Black patients literally died on the steps of hospitals that refused to treat them based on the color of their skin. That was during a period known as Jim Crow. We have now entered a period of Jane Crow, where women, depending upon where they live, may not get service and treatments according to federal law. This shameful legacy was, at least in part, addressed by EMTALA. However, in the wake of Dobbs, some anti-abortion state lawmakers stunningly claim that the federal law does not reach pregnant women, pregnant patients in need of health care that involves abortion. For this reason, as my colleagues, Professor Ellison Wayland, Larry Gostin, and I wrote in the Journal of the American Medical Association, despite what appeared to be a victory in Moyle v. United States, which allowed abortions in Idaho to continue for now in life-threatening circumstances, all Americans should truly be alarmed. In that case, the court explained that it was imprudent to take the case and returned it to the Ninth Circuit for further review. This was a procedural holding. It's worth noting that for more than 20 years, dating back to the George W. Bush administration, the Department of Health and Human Services, HHS, has interpreted EMTALA to require pregnancy termination if it represents the stabilizing care necessary to save the pregnant patient's life or prevent grave harm to health. Where are we in the United States today? We are the leading industrialized nation in terms of maternal mortality and maternal morbidity. We rank somewhere around 55th in the world, a ranking that is worse than countries that have experienced genocide and been in war-torn circumstances. Women are literally dying, bleeding out in parking lots, having to travel by car, by plane, however, in order to get the life-saving care that they need. And this affects them, and it affects girls as well.
Thank you very much, Ms. Goodwin. And let me start the questioning by just kind of getting us back to black letter law. There is federal law, EMTALA, which guarantees that anyone entering a hospital that receives Medicare funds, which is most hospitals, will get the emergency health care they need, reproductive or otherwise. This federal law is under the jurisdiction of this committee. That is why we are here. Professor Goodwin, why is it, given what I just said, why is it that women's emergency health care is under threat, despite a federal law that requires it?
This is directly because lawmakers that take an anti-abortion stance have created penalties that are so strict and severe that it places fear in the hearts and minds of doctors, the risk of losing their medical licenses to practice, the risk of criminal punishments in Texas up to 99 years incarceration, the risk of civil penalties and fines up to $100,000. And there have been lawmakers in South Carolina and Louisiana that have proposed the death penalty against doctors that would seek to provide the care that they trained for to help women.
Okay. Ms. Joshua, if you would just summarize, this is going to be a busy morning in the Senate, and your testimony was so important. Why were you turned away from 2 emergency rooms in Louisiana when you were in desperate need of emergency treatment for your miscarriage?
Thank you, Senator Wyden. It was due to our state's egregious laws, our state's abortion ban, which, again, as Ms. Goodwin has pointed out, has a chilling effect. I think a lot of times we talk about, the law in context, physicians being able to translate it and still be able to provide the care that women like myself deserve. But when you have local government that also creates a chilling effect via a letter telling physicians that they can face fines and fees, jail time, losing their license, and threatening their practice, then physicians have to put themselves first and are unable to make the decisions that affect folks like myself that are pregnant patients in need of care. And I know in that moment when I sought care from 2 different hospitals, it was really difficult to look the physicians in the eye and see that they could not even engage with me around the word abortion, and in that moment could not put me first, but instead were concerned about the ramifications of helping me having a miscarriage or navigate having a miscarriage at 11 weeks pregnant.
So it's clear that this kind of case is not isolated. Last week it was reported that a woman tragically died in a Georgia hospital because she was denied the emergency health care that she needed. And as a result now, I've sent letters to a number of hospitals where women have been turned away from receiving essential emergency care, including the facility that you we're dealing with, Ms. Joshua. We're going to have to get to the bottom of this because this, as far as I can tell, is happening all over this country. And I want to go next, if we might, to you, Dr. Huntsberger. Given the fact that physicians seem to be trying to figure out how to find a place where they can safely practice, tell us a little bit more about these threats that made you move and upend yourself from the place where it sounds like you wanted your family to stay forever.
Thank you, Chairman Wyden. Yes, we thought that Sandpoint would be our forever home, so it was a really difficult decision to uproot our family and leave. It also was true that it was clear that it was inevitable. If we stayed in Idaho, at some point, there would be conflict between what a patient needed and what the state laws allow for. Again, in Idaho, there is not an exception to protect the health of a pregnant patient. There is only an exception to protect the life of a pregnant patient. So I knew at some point I would be in that very uncomfortable position of trying to decide who to prioritize, my patient or myself. That is not how I want to practice medicine, and that is not how I've ever had to practice medicine prior to the abortion bans.
And I gather obstetricians in the post-Roe environment are having these difficult choices daily now. And I understand you and others have been talking about one physician who compared it to being in the Army and being deployed to Iraq.
Yes, she has practiced medicine for quite some time and served our country in the military. And she did remark that even despite going to a war zone, she didn't require counseling for that. Yet, providing medical care in Idaho has necessitated her seeking the professional help of a counselor because of the challenge of practicing that circumstance. You're exactly right.
Thank you for these responses. And I'll just say, it looks to me like emergency health care in this country is facing a 4-alarm fire. And we're going to stay at it until we get this fixed because there's a federal statute, a federal black letter law that says these protections are supposed to be offered. Senator Crapo.
Thank you, Mr. Chairman. And Mr. Chairman, Senator Blackburn has another need to get to another meeting and has asked if she could go first on our side.
Yes, that's fine.
Thank you, Mr. Chairman, and thank you to each of you for being here today. I want to begin by re-emphasizing a point that Senator Crapo made, and that is the irresponsibility shown in the titling of this hearing today. And as he said, never in a committee, never, to my knowledge, has the name of a presidential candidate been invoked in a hearing title, especially in such a villainizing manner so close to an election, which is 6 weeks from today. At the heart of today's discussion is a fundamental truth. It is that life is precious and every single life at every stage is worth protecting. And when the Supreme Court restored the voters' right to have a say in their state's abortion policies, we began to see laws recognizing this around the country. Unfortunately, there has been widespread and misleading claims suggesting that these laws require physicians to wait until a woman is on the verge of death or severe and irreversible harm before they can intervene. No law in this country mandates that a physician ignore the needs of pregnant women in medical emergencies. Ms. Hacker, I want to come to you. Could you confirm if any states in America prevent physicians from treating women facing life-threatening complications during childbirth? And could you clarify how state laws allow doctors to act based on reasonable medical judgment without requiring imminent danger to the mother's life?
Yes, I can Senator.
Microphone.
Sorry about that. Thank you, Senator. Yes, that is true. Every state that has an abortion restriction has an exception that allows a doctor to perform an abortion in the reasonable medical judgment of the doctor if it's necessary to prevent the death or protect the health of the woman.
And do any states call for the prosecution of a woman who receives such care?
I'm not aware of any. Most states actually explicitly exclude the pregnant woman from prosecution, and other states, the way their laws are written, for example, Georgia.
Thank you for that clarification. I appreciate that. I think the misinformation that has been spread about state laws protecting life has created serious risk for pregnant women, even resulting in tragic and preventable deaths. It's critical that women receive accurate information. So can you address how the misinformation, particularly from the media and other sources, may contribute to unnecessary confusion, whether it's from providers or from patients, and fear in medical settings, and prohibit them from getting proper care?
Yeah, I think one of the Georgia cases is a good example of that, Ms. Miller. According to the article in ProPublica, she actually did not ever seek medical care after she took abortion pills that she ordered online. And her family told the coroner it was because of abortion laws in Georgia. But if she was afraid that she wouldn't be able to get care, the laws in Georgia specifically allow for her to be treated. And also the laws in Georgia do not allow for her to be prosecuted for taking those abortion pills. So that's an example of, if that's true, what it was reported, that she didn't seek medical care. It's as a direct result of legal misinformation.
Okay. And Dr. Francis, I want to come to you for just a moment, because I think correcting the misinformation and making certain that people get the care they need is vitally important. Ms. Joshua, I appreciate how brave you've been in sharing your story. And I introduced the Woman's Right to Know Act earlier this year, which would set some long overdue medical standards that most states have already implemented so that women across the nation are provided access to vital information by their medical provider. It includes, number one, all the medical risk associated with an abortion procedure, and number two, the probable gestational age and development features of the unborn baby. and that this information go to the patient 24 hours in advance. So Dr. Francis, how would this type of legislation enhance the health and safety of pregnant women?
Thank you, Senator. Well, one of the tenets of medical ethics is informed consent, which means that if a woman is going to make the decision to have an abortion, she should be given fully informed consent, be told about all of the risks, benefits, and alternatives involved with any decision. And so, we think that it's very important that women not only be given informed consent, but be given accurate information about the risks that they're potentially facing and have a personal interaction with a medical professional, not the way that it's being done right now where these pills are being dispensed online with no interaction. And women deserve to have accurate information about their state laws as well so that there will be no delay in them seeking care. And physicians need that as well so that they don't delay in caring for women experiencing miscarriages and other medical emergencies.
The time
Thank
of
you,
my
Mr.
colleagues
Chairman.
expired. Senator Cantwell will go next, followed by Senator Crapo.
Thank you, Mr. Chairman. Thank you for holding this important hearing. And I'm dismayed at my colleagues on the other side of the aisle and even some of the witnesses because you're simply saying this is either rhetoric or hospitals don't understand the law. I guarantee you, Dr. Huntsberger next to you and our witness, Ms. Joshua, are not rhetoric. They're real life facts of what's happening on the ground. So in Idaho, she is an example of the many doctors who are leaving. 1 in 5 OBGYNs are leaving. They're leaving that state. They're not doing it because they want to. Trust me, my colleague from Idaho, I'd love to retire in Sandpoint, Idaho, okay? It's a beautiful place. But people leaving there, they're leaving for a reason. And the fact that we did a report that showed that the state of Washington is now being impacted by that, a 50% increase in abortion care in our state just because other people are coming there. In Idaho, our report showed, quote from Dr. Ed McGowan, we've been flying out about a patient a week to Utah or Oregon or Washington because the fetus is non-viable or the life of the mother is at risk, end quote. So I don't care what the lawyers are saying. This is what's happening on the ground. And the consequence is that it's affecting these individuals and threatening their lives. So Dr. Huntsberger, what more can we tell people about why 1 in 5 OBGYNs are leaving? Now, why do I care so much about this? I care generally about women's access to health, but I also care about the state of Washington right on the border. Because if you have deserts of gynecological care overall, it's going to cause problems, not just for the women in Idaho, but for our region as well. We want people to be able to see their physician. So the lawyers are just telling you don't have to worry about this, but you took a step to worry about it. Why did you take that step?
It was essential for me to be able to provide the health care that my patients needed without government interference. As you alluded to, the really challenging circumstances that both pregnant patients and doctors find themselves in Idaho puts everyone at risk. As doctors like me leave, that just worsens maternity care deserts in Idaho. Idaho has some of the lowest per capita number of physicians, so already there was a physician shortage there, and this is being greatly exacerbated. You mentioned concern about Washington, bordering states. I think that that's really another thing that we need to focus on. In states without restrictions, sometimes people feel that the abortion bans are not impacting them. Some of my friends practicing in Colorado, which is another state that saw a large increase in patients seeking care for abortion, then found that that was impacting their own citizens, meaning because of the influx of patients coming from other states for legal abortion care, for safe abortion care, their own citizens in Colorado had more difficulty accessing routine screening and their own care needs, pap smear testing, breast exam, contraception, the various things that people see an OBGYN for. So both restricted states are suffering harm as physicians leave, and states without restrictions are having impact as their own citizens may have more difficult time getting appropriate and timely health care.
Yes, so people playing politics with healthcare is even affecting Washington and other states for people to get basic gynecological care. Very concerning. But I'm also very concerned by today's comments and testimony that somehow this is just a legal issue and that it's all good, because it's not all good in Idaho. Not if one patient a week that where the life of the mother is at risk is being flown out to another state. Do you think that's meeting the definition of safe?
I think it's highly concerning that patients would need to take a helicopter trip in order to be able to access safe health care. That is very upsetting to me as a doctor and as a mom.
Thank you, Mr. Chairman.
Thank my colleague, Senator Crapo.
Thank you very much, Mr. Chairman. And, in response to my colleague from Washington, it is an issue of what the law says. The whole reason for this fear that you are describing here is because of a belief of what the law says. And Ms. Hacker, I want to go to you. You've answered this question multiple times, but it doesn't seem that your answer is being heard. My colleagues are talking about federal law, EMTALA, and that it protects the rights of women to get treatment for emergencies. And there is a lot of other discussion about different aspects of the law. Are there any state pro-life laws in America that require imminence or certainty before a doctor can act to save a patient's life? Or can a doctor in all 50 states under the law today follow and meet the standard of EMTALA?
All doctors can exercise their reasonable medical judgment in determining whether an abortion is necessary to save that woman's life or prevent her death in all 50 states, Senator.
And there are some who say, well, there's confusion about whether the state's going to penalize them or fine them or imprison them if they do follow this reasonable judgment. Can you tell me how many prosecutions did you say there were in the entire country of prosecuting a doctor for using their reasonable judgment in deciding how to treat a woman?
In preparation for this hearing, I did some searches, and I was unable to locate a single reported case anywhere in the country of a doctor being prosecuted for performing an abortion based on his reasonable medical judgment that it was necessary to prevent the death of the woman.
So that it's obvious to me that there is some confusion about the enforcement of the law that doesn't exist across this country. Dr. Francis, what's your position on this with regard to the confusion? There clearly is a fear among doctors that has been shown here that there is going to be some kind of an enforcement against them or some kind of punishment of them. Can you tell me what you believe the reason for that confusion is?
Yes, thank you, Senator. I agree with you that I see confusion with some of my colleagues, and certainly we're hearing that, and that's leading to women's care being affected. However, again, it is not the fault of the law. It is the fault of rhetoric that we're hearing, not from physicians, but from other sources. And it is the fault of the organizations that should be properly explaining the law, not properly explaining the law. Some of our major medical organizations that should be helping clarify for physicians are not doing that. Some of the state medical associations that should be doing that are not. Doctors need clear guidance. If I can just give a quick example of what clear guidance looks like. My own hospital system in Indiana, when our law went into effect, which has robust pro-life protections, the guidance that we received from our hospital is our practice doesn't change. We practice exactly the same as we always have. We can continue to provide needed care for women.
All right, thank you. And let me go back to you, Ms. Hacker. Could you describe to me, the chairman mentioned that it's black letter law that our committee has jurisdiction over, and that's EMTALA. Could you describe what the standard of care of that federal law is, and tell me whether there is any, again, whether there's any state law that challenges or interferes with that federal standard?
No state abortion law would prevent a doctor from providing needed emergency care to a woman if it included abortion under all of the exceptions to abortion laws. And again, things like miscarriage and ectopic pregnancy don't even qualify as abortion. So if there was emergency care needed in those situations, it wouldn't even be affected by abortion laws.
And what is the standard of care that EMTALA requires?
So the general standard of care is reasonable medical judgment. And actually, I'd like to add in Idaho, the standard is actually lesser. It's good faith medical judgment, which is a subjective standard that doesn't depend on the standard of care. So it's actually a less strict standard than elsewhere. Just wanted to clarify that point since we were talking
So
about Idaho
standard
law.
is actually less strict than
Yes.
the federal standard?
I'm not sure exactly what the precise standard is in that federal law, but that is the general standard of care that is accepted for medical practice.
All right, thank you very much.
So I'm going to go to Senator Carper in a second. I just want to make sure that I'm clear about some of what we just heard. What we just heard is some discussion about, from one vantage point, that there is no place in America where doctors can't exercise their judgment to treat patients. Well, I don't think that's the case, and I think Ms. Joshua is Exhibit A that it's not the case, because that's what she was faced with. Senator Carper.
Thanks, Mr. Chairman. I think I had the opportunity to meet several of you before the hearing began. We've had a variety of committees meeting, and so we're kind of coming and going, as you know. And thank you for being here and responding, for your testimony and for your willingness to respond to our questions. And in particular, I want to thank you, Ms. Joshua, for sharing your knowledge and your personal experience with all of us today. Since the Supreme Court's, I believe, the extreme decision overturning Roe versus Wade, 22 states, I'm told, some 22 states have enacted total abortion bans or severely restricted access to abortion. In fact, today I'm told that 44% of women of reproductive age do not have access to abortion care within their home states. As today's hearing and as Ms. Joshua's testimony demonstrates, we are seeing the consequences of these abortion bans across our country. They are dangerous in many cases to women's health, and in some cases, actually deadly. So, Mr. Chairman, colleagues, I support, and I think a majority of Americans do as well, continue to support women's rights to make their own health care decisions. And at a time when these most personal decisions and access to reproductive health care are under attack across our nation, we must work together to protect the fundamental right to access reproductive health care. Ms. Joshua, question I have for you. In your testimony, you talked about the impact on your own health care because of state restrictions on abortions. What would you want members of our committee to know about the dangers of extreme laws that would override the choices made by women and their doctors?
Yeah, thank you for that question. Senator, first I would want the members of the committee to understand that basic maternal health care is being directly impacted as a result of these egregious laws. I understand that others are insinuating that these laws are easy to interpret. Physicians have the discretion and expertise and training to be able to make the decisions, but we don't, right? They don't. And essentially my story, what I think it speaks to is this overarching issue where we're still kind of arguing, is abortion care health care? Is a miscarriage deemed necessary to be able to provide abortion care? Other definitions have kind of been thrown out here and there through the course of this, the messaging that we've heard this morning, and I think those are dangerous statements, and the very reason why places like where I live in Louisiana, we're seeing direct impacts, especially to women of color, in particular Black and Indigenous women are feeling the brunt of these egregious laws, and this will continue until we clear up and clean up the language and provide for abortion care in all 50 states, not just some. And so I hope my story speaks to all those points and also adds a layer around Black maternal health care, which is already really alarming and starking in terms of statistics around maternal morbidity rates, fetal morbidity rates. It's very alarming, especially in the Deep South. And when you add this other component of an abortion ban, it does not seek to address the issue, but instead exacerbate it.
All right, thank you for that. Physicians are increasingly leaving states with restrictive abortion laws, effectively reshaping the national healthcare workforce and exacerbating existing provider shortages. In states with restrictive abortion laws, physicians are caught in, I would describe as a bind. On one hand, they face a potential legal prosecution for providing abortion care under restrictive state laws, while on the other hand, they may face legal action for malpractice if they deny necessary care. As a result, hospitals are seeing providers leave their states to avoid legal risk, further straining healthcare systems and reducing access to care. Make no mistake, in addition to putting women's lives in danger, these extreme and restrictive abortion laws are oftentimes putting doctors in what I would describe as impossible positions, legally and ethically too. Dr. Huntsberger, what should Congress, and in particular members of this committee on which we serve, what should we understand about the challenges facing physicians to care for patients, and the same physicians facing potential prosecution for providing reproductive care, often life-saving care to their patient? Please, Dr. Huntsberger.
It is extremely difficult to legislate pregnancy and prenatal care, which is very complex and nuanced. Given the challenge of legislating medical care, because it can be so complicated, we shouldn't. These are the real impacts of government interference in healthcare, and it's a big problem, and it's affecting women across the country. Thanks for your question.
Yeah, a question for the record, if I could. Dr. Huntsberger, would you provide for us, for the record, some examples of how these extreme abortion bans are hindering the training of the next generation of healthcare providers? Thank you, for the record.
Thank you all. Thank you,
Thanks,
Senator
Mr.
Carper. Senator Johnson's next.
Thank you, Mr. Chairman. The title of this hearing is offensive as it is false. The Dobbs decision criminalized nothing. It just sent back the decision to the states, again, the profound moral issue, back to we the people. And I think the question that has to be decided is, at what point does society have the responsibility to protect the life of a baby in the womb? Now, Dr. Huntsberger, is there any point in pregnancy that you think a healthy baby's life ought to be protected?
I think healthcare decisions should be left between a patient and the doctor.
So there's no point that you think a healthy baby's child should be protected inside the womb? You get a simple yes or no answer.
I think it's clear that the abortion bans are very significantly and negatively impacting patients.
Okay, you refuse to answer the question. I would like to play, but apparently I'm not able to, a call into a late-term abortion facility, a woman saying that she was 34 weeks pregnant and she wanted an abortion, to listen to the provider describe exactly how they are happy to perform that abortion, how they do it all the time, is abhorrent. But I'll enter it into the record, seeing as I can't play it here. Just to verify that, check to see, are there really things like late-term abortion clinics? There are. They perform abortions up to 35 weeks. Dr. Francis, how viable is a baby at 35 weeks?
Well, thankfully, because of advancements in medical technology over the last 50 years, we've moved the point of viability of a baby outside the womb from about 28 weeks at the time that Roe was decided, down to now in some centers, baby as young as 21 and a half weeks gestation can survive. So at 35 weeks, with appropriate medical care, nearly 100% of babies will be able to survive.
So the extreme position on abortion is no restriction. Abortion basically up to the moment of birth of a completely viable and healthy child. That is the extreme position on abortion. When I hear this abortion bans, it's not a ban when you set a reasonable time period. And different states have different time periods, 12 weeks, 15 weeks. In Wisconsin now it's 20 weeks, 20 weeks. And all we're trying to do is protect life after that point. That's not a ban, that's protecting life. Again, let me go, this is, listening to the testimony here, it's like there's two totally different realities. Professor Goodwin is using terms torrid pandemonium, bleeding out in parking lots. Dr. Francis, is that the reality you're hearing? I mean, how many women have we been reported have been bleeding out in parking lots? And by the way, if they are afraid, maybe it's because here in the United States Senate's Finance Committee, we're holding a hearing that says women's health care now is criminalized. Maybe a title like that in a hearing is causing the chaos and the control. But Dr. Francis, I mean, is that a reality that you're witnessing at all? pandemonium, bleeding out in parking lots? Is that just an everyday thing now?
I'm certainly not seeing that in my practice because I, like every other physician in the state of Indiana, intervene when I have a woman in front of me who's facing an emergency. I don't send her out to her car. I don't send her home and tell her to come back when she's more sick. I intervene immediately. Unfortunately, we are hearing circumstances of that, but again, I think it's important to understand whose fault that is. That's not the fault of the state law. Every state law provides clear exceptions for physicians to have actually wide latitude to intervene in an emergency if they are withholding treatment and they're not intervening. It is coming from a lack of understanding, which means that all of us on both sides of this issue should join together and call for better education of the public and better education of physicians.
So when there are politicians who refuse to acknowledge the fact that they want abortions up to the moment of birth, they won't be honest with the public, holding hearings that say now that women's health care is criminalized, maybe, just maybe, that type of rhetoric is seeping through into the consciousness of doctors, producing really a very regrettable situation like Ms. Joshua experienced, correct? I mean, I have no other explanation for that. If the laws don't prohibit it, again, I can't explain why doctors would not treat because they're perfectly legally able to do so, correct?
I would agree with you, Senator. I think Ms. Joshua's story and the story that we heard from of Mrs. Miller last week are direct evidence of how these lies and misinformation that are being told about what state laws actually accomplish have direct harm on our patients.
I would say the title of this hearing is more dangerous and threatens more lives than the laws that I think you've ably described as allowing the kind of health care that saves mothers' lives. Thank you, Mr. Chairman.
My colleague just said about you, Ms. Goodwin, that you were using incendiary language, assuming something inflammatory. I just want to give you a chance to respond, and then we'll go to Senator Cortez Masto.
Thank you very much, Senator. I think that we should have an intellectually honest hearing today and not subject ourselves to a twilight zone. I recognize Ms. Joshua and what she experienced. I have testified sitting next to Amanda Zarowski with her husband right behind us. Kate Cox, her story became one heard around the world, where the state's attorney general intervened after a district court judge said that she should be able to terminate a pregnancy in order to save her life and future fertility. And he intervened by sending letters to hospitals threatening them that if they were to provide care to her, they would be punished. Brittany Watts in the state of Ohio was threatened with criminal punishment after 3 times seeking medical care, going home and having a miscarriage. Her bathroom was destroyed. Police broke open her toilet, searching for fetal and fecal remains after she had a miscarriage. These stories have been reported across the country. These stories have taken shape in the state of Wisconsin. Our failure to understand this is essentially blaming the women who've had these experiences after the Supreme Court overturned Roe v. Wade and Planned Parenthood v. Casey. And the best that we could do is be intellectually honest, caring and compassionate towards these individuals, including Ms. Joshua today, who told a very compelling story and has been honest about her experiences.
I appreciate your response. Senator Cortez Masto.
Thank you. And let me add to this. First of all, Ms. Joshua, thank you. Thank you for coming here and telling your story. And Dr. Huntsberger, I want to thank you, because this is reality. Whether you agree with it or not, this is what's happening. And Ms. Goodwin, I want to talk to you as somebody who is an attorney, a legal scholar, constitutional law. There is a thing that happens when we pass a law that also may have a chilling effect, and that's the intent of the law, to also further hinder any type of activity. Isn't that correct?
That is absolutely correct. And this has been a pattern as part of an anti-abortion playbook even before the Dobbs decision, with targeted regulations against abortion providers, which were shutting down clinics across the country. And one thing that is really important connected with your question is that that chilling effect began shutting down clinics, and those were clinics that provided prenatal care, postnatal care, contraceptive access, access to sexually transmitted disease, screenings, all of that. And when those clinics shuttered, that meant that people who even needed prenatal care and wanted to be pregnant could not get care and were dying. This is why we lead all of the industrialized world in maternal mortality and maternal morbidity.
And that was the intent of this anti-abortion movement. It wasn't just let's give it to the states and let them all decide. It was really just this focus of shutting things down, shutting access to care, having this chilling effect. And we're seeing it. Whether you believe it or not, it's happening. It's happening across the country. And it is important for, I think, people to understand that's the intent here, and it is reality. And Ms. Hacker, I appreciate your legal skills because, you know, as an attorney, I was told one time by a partner, as a young attorney, when you go into the law in that courtroom, the law is that which is boldly asserted and plausibly maintained. You can boldly assert, plausibly maintain your argument, and I can do the same things with the facts on my side. But at the end of the day, that does not help the women who need health care and access to it. That does not help women who really are looking for access to 21st century medicine and relying on their doctors and the science to help them and their families. And I don't care what anybody says today, as a woman, I don't want anybody in that room other than me and my doctors and my loved ones making that decision. No law across this country, no elected official across this country should be making that decision for women. And that's what this is about, the right to choose and the freedom to choose. You may be a woman who doesn't want to have an abortion, and that is fine. That's your choice. But you may be a woman who needs it, and you want to rely on a doctor who is free and not afraid that they're going to get criminalized and penalized because they're providing what they want to do under their Hippocratic oath. And let me just say, all the laws across the state are not equal. I am sorry, Dr. Francis, they're not. I have a Texas law right now that basically says an abortion cannot be performed, and if it does, in this exception, the patient must have a life-threatening condition and be at risk of death or substantial impairment of a major bodily function if the abortion is not performed. But substantial impairment of a major bodily function is not defined in the law. So now we're telling doctors, you got to do specifically defined based on the law that we have provided. And we're asking them to interpret legal interpretation. I don't want that to be happening in a medical situation and when I'm talking to my doctor. So there is so much misinformation, but I have to tell you, the facts and the reality are sitting right in front of us right now, and you cannot discount that. And let me, so Ms. Goodwin, let me ask you this, a couple of things. Former President Trump, and let me just say, is it true, as former President Donald Trump claims, that every legal scholar opposed the precedent set in Roe versus Wade?
That is absolutely false. You can look at the amicus brief submitted to the Supreme Court in the Dobbs decision to show that they were not in support of the overturning of Roe and Planned Parenthood.
And as we discussed, in your opinion, do you think anti-choice politicians are content with overturning of Roe v. Wade, or are you seeing politicians attempt to use other legal avenues to further restrict women's access?
They absolutely are. We saw in Arizona that the Supreme Court was willing to go back to 1864 to uphold a criminal abortion ban, a time before Arizona was actually a state and when Black people were still enslaved in the United States.
And does any doctor that you're aware of execute any child after birth?
No, none of us are aware of that.
And are you aware of, would any doctor want to take the life of the baby in the 9th month?
No, and none of us are aware of that.
And let me ask you this. When Roe v. Wade was in place for over 50 years, you know, Donald Trump said that for that 52 years, this issue has torn our country apart. Did it tear our country apart when Roe v. Wade was the law of the land?
That's not true. And the Supreme Court in Whole Woman's Health v. Hellerstedt made clear that a woman is 14 times more likely to die carrying a pregnancy to term in the United States than having a pregnancy termination. 2016.
Time of my
Thank you.
colleagues expired, and I appreciate the important question. Senator Warren is next, and I know, colleagues, it's been pretty hectic. Senator Warren, of the senators in the room, it would be Senator Warren, Senator Lankford, and Senator Casey. Senator Warren. Yes. Logistics.
Try not to interrupt. Excellent questions from Senator Cortez Masto. So it has been 2 years since Donald Trump's Supreme Court overturned Roe versus Wade. The consequences have been disastrous. Women hemorrhaging in parking lots until they are close to death. Women airlifted to another state for an emergency abortion. Women traveling from emergency room to emergency room, desperate for help, only to be turned away and left to miscarry at home. Ms. Joshua, I am deeply sorry for what happened to you. It should not have happened to anyone. Trump's abortion bans aren't just causing unnecessary suffering, they're killing women. Last week, we learned about Amber Nicole Thurman. Amber lived in Georgia. She was mother to a 6-year-old boy. She hoped to become a nurse. After learning she was pregnant, she fled to another state where she got a medication abortion. Back in Georgia, Amber experienced a rare complication. She waited 20 hours before doctors performed the life-saving surgery that she needed, but 20 hours made it too late. Anti-abortion extremists want to twist Amber's story to spread misinformation about the safety of medication abortion. Dr. Huntsberger, you are an OBGYN. How safe is medication abortion?
Extremely safe. We have decades of research on mifepristone demonstrating its safety. Risk of complications are always present with any medication, but are quite low. It's also important to note that both medications and treatment with surgical procedures are identical for the management of early pregnancy loss or miscarriage and abortion.
All right. So extremely safe is what I heard you say. And in the rare case where there is a complication, is it treatable?
Yes.
Eminently treatable. But anti-abortion extremists want to misdirect and cast blame on the providers, arguing that doctors are willfully misapplying the law. Dr. Huntsberger, tell us what's really going on here.
I think it's important that instead of trying to shift blame to physicians who are practicing in a really hostile and challenging environment, for us to look at why they're in that circumstance in the first place. And that is because lawmakers who may or may not have bothered to understand the complexity of pregnancy and medical care made laws that are impacting physicians' ability to act and to safely take care of their patients.
Okay, so the problem is not here with the physicians. It's with the lawmakers who are passing these laws. I think what we're seeing is Republican politicians who pass these medically unsound and dangerous laws that end up intimidating and confusing physicians who are just trying to provide care. Tragically, another Georgia mother, Candy Miller, died at home because Georgia's abortion ban made her afraid to seek the medical care that she needed. Amber and Candy should be alive today. Now, we have a federal law that is designed to prevent tragedies like this from occurring. The Emergency Medical Treatment and Labor Act, EMTALA as it's known, requires hospitals to provide stabilizing care to individuals in an emergency situation. Earlier this year, the Supreme Court heard arguments about whether Idaho's near total ban on abortion conflicts with EMTALA. Professor Goodwin, you're a constitutional law expert. Supreme Court did not actually resolve this. They sent it back to the lower court. What should we take away from this? Does this mean we are now safe and will have the protection in emergency circumstances? Go ahead, Ms. Goodwin. Professor Goodwin.
No, we should all be deeply alarmed by the Supreme Court's procedural move rather than substantively answering the question that federal law trumps state's law. It's been a principle in American law for over 200 years, and the Supreme Court's failure to be clear on that a state law does not preempt federal law is something that is incredibly dangerous.
Okay. Dangerous. I hear alarm bells going off. The stakes couldn't be higher. Thanks to Donald Trump, doctors in nearly half the country now have to wonder if they will face criminal penalties for providing medically necessary care. 44% of women of reproductive age now live in states where they don't get to make decisions about their own bodies. And 2 women, undoubtedly more, have now died because they were not able to access the timely care they needed. We must restore the protection of Roe to make sure this never happens again.
I thank my colleague. Senator Helmy's next, then Senator Langford.
Thank you, Chairman. I appreciate you holding this important hearing, which is essential to the protection of a woman's choice and an important issue to physical and mental health. And I appreciate your courtesy and that of the ranking member in allowing Tammy's testimony to be included in the record. Ms. Joshua, I share the comments of all of my colleagues on your courage in being here. Your response to Senator Carper's question has led me down a different tangent of questions than I think I was going to go, so forgive me for going down this road, but it's really important to me. You mentioned the choices that black mothers are having to make, and I'd love you if you could spend a little bit of time following the introduction of these bans, the inconsistencies in the application of federal law. We know that we have a maternal and infant health crisis in this country, even in states like New Jersey, where we have been thoughtful and progressive about our investments in community health. The data on outcomes for black mothers and black babies is wholly unacceptable. In light of the decisions that we've been contemplating here and the impact of those, I'd love just a few minutes of your thoughts on, in response to these, what decisions are you seeing communities of color having to make, and specifically the decisions that black mothers are having to make?
Yes, thank you for that question. And so we know, and I'm sure you know as well, Senator Helmy, that black mothers, black families are already disproportionately affected by the current maternity care deserts that lie within my state of Louisiana, now adding that, as I stated, extra burden of an abortion ban, which seeks to further discriminate against mothers when trying to seek emergency care, whether in the emergency rooms or in their local hospitals or facilities that they're near. I'm finding that a lot of mothers, and even really good girlfriends of mine that are currently pregnant, are choosing to go to New Orleans or go to other parts of the state that are deemed more sanctuary cities, if you will, around abortion care, and spending more money, spending more time away from work, having to find someone to help with their current child care to be able to see providers that they believe would put their best interest at heart and have their best interest at heart and would provide the care that everyone deserves in the state of Louisiana. But unfortunately, women are having to travel far, one, because they don't have the access of a local Planned Parenthood or any type of OB-GYN facility that may have once stood there in their community or their parish, but 2, because they also know that physicians in New Orleans practice, if you will, abortion care and are willing to do whatever they can to save the lives of mothers. I myself have been blessed enough to be able to have another baby. My son just turned 12 months, and my husband and I actually decided for me to, spend the extra money, drive to New Orleans an hour and a half away from where we live in order to see physicians that do believe in abortion care. No one should have to take on that burden simply because they don't want to put their lives at risk even more than it already is, and also, be faced with not being able to come home to their children that already exist and their children they already have at home and their families that are wanting them back safely. And so women are having to take on these extra costs. It's unnecessary, but we're willing to do it if that means that we can safely return home to our families and, be here to advocate for the maternal health crisis that I speak of.
Thank you. Thank you, Ms. Joshua, and thank you for being here. Professor Goodwin, you've been a thought leader and a scholar on the issues surrounding reproductive health, specifically access to it. One of the issues that I have been working on from my time in state government and my short time here in the Senate has been mental health. And I'd love if you could give us your thoughts on what are the points of consideration when we think about limiting access to health, specifically among young women who we know in certain communities, 1 in 4 young women have made self-harm plans. If you could talk specifically to the impacts on limiting access to youth mental health, specifically among our young women. Thank you.
Well, so much of this could be predicted in 1973 in Roe v. Wade, where Justice Blackmun spoke to quite specifically the mental health harms, the physical harms that would result from girls and women being forced into a motherhood that they were not prepared for and did not want. And the same is taking place today. Suicide risk, deep mental health trauma. We have seen in the wake of Dobbs that states have passed abortion bans that provide no exceptions for rape or incest. Immediately after the Dobbs decision, we all learned the case of a 10-year-old girl escaping Ohio to get to Indiana in order to terminate the pregnancy, and lawmakers there saying it was a hoax and that she didn't exist. Almost kind of like what we're hearing today. She did exist. She had been raped. She was trying to survive that. There are cases today in the United States where there are little girls going into elementary and middle school as mothers after the Dobbs decision. It is a trauma that they will live with. It's a trauma that their families are living with. There are cases of young women who are trying to use judicial bypasses and being told that they're too immature to have an abortion, or that they don't have sufficient grades in order to be able to terminate a pregnancy. These kinds of traumas have lifelong consequences.
Thank you. Thank you, Professor, and thank you all for being here and participating in the debate. Thank you, Chairman.
I thank my colleague. Senator Grassley is next.
I'm leading up to a question for Dr. Francis. I've received messages from women in Iowa who had experienced ectopic pregnancies and who heard that Republicans want to prohibit treatment for this medication. Naturally, these letters were from constituents very upset. These Iowans almost certainly heard disinformation designed to cause maximum upset for partisan political purposes. These sort of pregnancies treatments is not abortion. No one in the pro-life community thinks so. Doctors have always known the difference. Republicans are not trying to prevent care for this life-threatening condition. Whoever told them that we are ought to be ashamed. Given the title of this hearing, I'm concerned that the purpose of today's hearing is along those same lines. Women experience heart-wrenching medical conditions deserve treatment, not partisan disinformation. So how do we counter this political disinformation? Specifically, how can we make sure that both doctors and patients get accurate information about pro-life laws so women can access needed care for conditions like these pregnancies and miscarriages?
Thank you, Senator. I think it's extremely important that we take a deep breath and look at what the laws actually say and then give accurate information about those laws. As you said, there is not a single state law in this country that prevents doctors from treating ectopic pregnancy. We have always recognized that the treatment of ectopic pregnancy is not an abortion. In fact, even Planned Parenthood recognized that on their website. And so these laws do not prevent us from treating the life-threatening condition of ectopic pregnancy. I think who we should be looking at are those that are advocating for abortion drugs to be dispensed online without any in-person visit, because then no meaningful screening for ectopic pregnancy can happen. And we know that 1 in 50 women who are pregnant will be pregnant with an ectopic pregnancy that, again, could be life-threatening. And the symptoms of an ectopic pregnancy are exactly the same as the symptoms a woman experiences when she takes the abortion drugs: abdominal pain and bleeding. And so if she thinks that those are normal symptoms related to her abortion and she stays at home while her ectopic pregnancy has ruptured in her abdomen and she's bleeding in her abdomen, she is going to be at significant risk of death. And in fact, we know several women have died after taking the abortion drugs because of an undiagnosed ectopic pregnancy. If we care about women receiving treatment for ectopic pregnancy, we should come together and demand that these drugs stop being dispensed without an in-person visit.
Yeah, and also for you, we must improve maternal and child health, especially in rural America. And I suppose I should include the inner cities in that as well. In recent years, I've sought to improve data collection, address disparities in mental health, help pass legislation to prevent stillbirths, and have introduced my bipartisan Healthy Moms and Babies Act. It's a comprehensive bill to improve care coordination, increase access to telehealth and remote monitoring, and take additional steps to reduce maternal mortality. So you talked about it in your testimony, how you've treated countless complications throughout pregnancy and in postpartum period. What steps can we take to improve maternal and child health care?
Thank you, Senator. I think you've touched on several of the things that can be done to improve maternal outcomes. I agree with some of the other witnesses here that most maternal deaths are preventable, but they're not preventable by giving a woman an induced abortion. They're preventable by providing actual prenatal care, getting women into prenatal care early, ensuring that women have childcare and transportation to be able to come to their prenatal visits, and then ensuring that women have a labor and delivery unit with an obstetrician gynecologist to come to. I have with me a document from out of Minnesota, but that looked at closure of obstetric services in hospitals across the country in rural areas that showed that this started back in 2010, well before the Dobbs decision. It is a problem. Maternity health care deserts are a problem, but we are not going to fix that problem by legalizing abortion through all trimesters of pregnancies. We will fix it if we actually put our heads together and come up with real solutions for women that we know will reduce our maternal mortality rate. And I think that women across this country deserve that. They deserve for us to come together across the aisle and come up with real solutions. And we know that induced abortion is not that solution.
Okay, I'll yield, Mr. Chairman.
I thank my colleagues. Senator Hassan's next.
Thank you, Mr. Chair and Ranking Member Crapo, for holding this hearing. Thank you to all of the witnesses for being here today. More than 2 years ago, Supreme Court justices appointed by former President Trump overturned Roe v. Wade, taking away a woman's fundamental freedom to make her own personal health care decisions. Now, tens of millions of American women live in states where abortion is banned. Some states would send women who seek abortions, as well as their doctors, to jail. Some of these laws mean that even women who miscarry would be investigated and sent to jail. We cannot let the women of America become second-class citizens. Dr. Huntsberger, I want to start with a question to you. I want to discuss the irreparable damage that abortion bans are doing to the healthcare workforce. In some states with abortion bans, medical students and residents aren't able to receive the hands-on training that they need in order to treat pregnancy complications, including ectopic pregnancies and miscarriages. Or they're worried about practicing medicine in a state where they could go to jail for providing reproductive health care to their patients. Doctor, can you discuss how abortion bans are affecting medical students and doctors' decisions about where to train and practice?
Thank you for this question. I think it's really important. In Idaho, this manifests as medical students deciding whether or not to come to Idaho for family medicine residency, and many are deciding not to apply or not to go there as a result of the bans and the negative effect on their medical education. We're seeing this not just in Idaho. This is happening across the country with specific impact on OBGYN and family medicine, but it affects all specialties. So medical students looking at various specialties are less likely to choose to get their education in a state with an abortion ban. Another point that I think is important is to think about residency training, so that next step beyond medical school. In Idaho, there is no OBGYN residency. So every OBGYN who lives in Idaho moved from somewhere else. So again, and know that many people stay and practice in the place that they trained. When people are looking at options after a residency, most won't choose to go to a state that criminalizes healthcare.
Right. And if obstetricians and gynecologists can no longer train in certain states, what are the implications for women seeking basic health care in those states?
It's huge. You know, in residency training, you see a lot of patients, you take care of a lot of different circumstances, and it's that repetition of providing care to many different people and seeing many different complications of pregnancy that allow us to hone our skills and understand how to best take care of our patients. So if there becomes a greater discrepancy of where physicians are getting appropriate training and where they're not, that not just impacts those physicians, but that also impacts the communities and the states that they're in. So there is a profound impact on patients as a result of the bans related specifically to medical education and residency, but also, and most importantly, on patients generally speaking.
Right. Thank you. Dr. Huntsberger, I'm going to follow up a little bit on the line that Senator Grassley was just talking about. It is clear that abortion bans and workforce shortages are already impacting women's ability to access health care, anything from routine prenatal care to emergency miscarriage treatment. 11 maternity wards have closed in New Hampshire in the last 2 decades, leaving only 15 hospitals where women can give birth. The median driving time to a labor and delivery unit has doubled to about 40 minutes in New Hampshire, and it's much further for some of our most rural residents. Dr. Huntsberger, we discussed maternity deserts, and yes, they have existed before the Dobbs decision, but how are abortion bans exacerbating existing maternity care deserts?
I think we can look at the community that I came from for an example in Sandpoint. So patients who came to see me for routine prenatal care often traveled anywhere from 30 minutes to an hour and a half, sometimes traversing 2-lane roads in winter conditions. Now patients have to travel another hour to find care. So what does that mean for the person who was an hour and a half away to now add an additional hour of travel? I obviously still know many patients in my home community. This has a huge impact. We heard from Ms. Joshua, paying for childcare, getting time off of work, having to travel an hour each way for every 15-minute obstetric visit. This is a huge burden, time, financially, and otherwise. Many of my patients I have heard from who are terrified that they won't recognize that they're in labor, or their labor will proceed so quickly that they won't be able to get to the hospital in time and might have their baby on the side of the road.
Right. I thank you for that answer. It's clear that abortion bans are making basic health care less available to women. And before I turn it back to you, Mr. Chair, I just want to thank Ms. Joshua in particular for sharing your experience. It's really, really important that we hear directly from people impacted by these laws. So thank you so much for being here. Thank you, Mr. Chair.
I thank my colleagues. Senator Bennett is next.
Thank you, Mr. Chair. Thank you to the witnesses for being here. Dr. Huntsberger, thank you for being here as well. I had a question for you. As you know, thousands of women are coming to Colorado from out of state to get reproductive care. And in the immediate aftermath of Dobbs, the Dobbs decision, wait times in Colorado clinics increased from a few days to several weeks. Providers all across the state have scaled up their operations to meet this need, and none of the providers that I know are complaining about the fact that they're having to do that. But because laws in other states continue to change, the need constantly evolves in Colorado. And this comes at a big cost, I think, to patients and to providers. I wonder if you could talk a little bit about how the influx of out-of-state patients hampers access to reproductive care in a state like mine, and pregnancy care for in-state patients.
I think you make an important point that not just the restricted states are impacted by these bans. I have actually specifically talked with friends who are practicing medicine in Colorado about precisely what you describe, the massive influx of patients seeking abortion care because it isn't safe or legal to do so in their own home state. That then impacts those doctors' ability to provide other care, including routine prenatal care, preventative care like pap smear screening and birth control prescribing to people who are from Colorado. So I think sometimes we forget how intertwined healthcare is. And when we have such strict laws affecting one aspect of healthcare, that then translates to negative consequences for other unrelated aspects of care.
Could you talk a little bit also about what that increased burden has on the mental health care of providers that are now having to contend with this influx that's created because other states have decided to change their laws?
I think it's really challenging. One of the things that we have seen in Idaho is patients being airlifted out by helicopter to other states in order to have access to safe, health and life-saving abortion care. Can you imagine being on the receiving end of that? A patient who previously could have been stabilized in their home state, then coming to you, the time that it takes to load a patient up in one hospital, to get them on a helicopter, travel somewhere else, then get unloaded from the helicopter so that their healthcare emergency can be addressed. This, again, has not just impact on healthcare teams in Idaho, but also the places that are receiving these patients who are sicker than they were before they left their home state.
One of the things, Mr. Chairman, that I just found so unbelievable when I read the Alito decision in the Dobbs case was there was no discussion at all about what the practical effects would be on women today. His view was, and you can look it up and read it, his view was if it's not a right or a freedom in 1868, it shouldn't be a right or a freedom today. None of these practical implications were considered at all, and when President Trump goes around the country and says everybody wanted Roe versus Wade reversed, that everybody, he says all Democrats wanted it reversed, that the law professors all over America wanted it reversed. I mean, it's patently false. It's not true. And he thinks he's making, I think, a compelling states' rights argument. And it ignores, first of all, the fact that what we're talking about here, in my view, not that no one has to share this view, but a fundamental civil right, a fundamental American freedom, the first one that we have lost in this country since Reconstruction. But even if you don't agree with that, the practical implications of not having this decided at the national level and, you know, quote unquote, leaving it to the states, as Donald Trump daily, on a daily basis, suggests the majority of Americans, not even the majority, a universal view of Americans, is that he was right to do it, utterly ignores the reality of what people are having to deal with. Most importantly, you know, women that are having to come to grips with this all over the country, doctors in my state and other states that are having to come to grips with this. And it's not surprising to me that there are states all over the country that are changing their laws, but the damage that's going to be done and inflicted in the meantime is damage that we should never have had to suffer. Doctor, I appreciate very much your testimony. And Mr. Chairman, thank you again for holding this hearing.
I thank my colleague for his important remarks, and I think Ms. Joshua is an actual example of what Senator Bennett described. The chaos and the discord led to the problems, in my view, that Ms. Joshua had, and we'll talk about it some more. Next is Senator Daines.
Mr. Chairman, thank you. We are 6 weeks away from an election, literally from today. And for the second week in a row, Democrats on this committee are taking political potshots on a most sensitive issue. This week, we are discussing recent and devastating medical tragedies that could have been avoided had the Biden administration not played politics with women's health. Today's hearing was called because Democrats are trying to find opportunities to score points on the only issue they think they stand a chance to win on in this upcoming election, with no regard for the truth. Fortunately, the American people are smart enough to see through this messaging stunt. The Democrats and the media, being complicit, are using these tragedies, such as the stories out of Georgia last week, to blame Republicans and red states for attacking women's rights and women's health care. Yet the irony is that these tragedies would have never occurred if the Biden administration and the FDA had kept the safety precautions for chemical abortions, including the in-person dispensing requirement and the follow-up visit with a medical provider in place. Let me be very clear, crystal clear. Vice President Harris and the left are engaged in a very dangerous game of demagoguery. They're blaming the deaths of these women on Georgia law. That is a lie. In the cases from Georgia last week, both women experienced the same complication from chemical abortion, where the medication failed to expel all the remains of their unborn children. This is a life-threatening risk that women are not made aware of when they access this medication without guidance from medical professionals. We must approach this issue with intellectual honesty so as to do some justice to the memory of Amber Thurman and Candy Miller and prevent such deaths from ever happening again. The truth is that the Biden administration has failed these women and women in general. The truth is that the Biden administration has lied to women by allowing them to believe it is safe to take chemical abortion drugs on their own without medical supervision. The truth is that Amber Thurman and Candy Miller would not have been left to take such risky medicine on their own if the Biden administration had not removed the medical supervisory requirements. Had these requirements not been removed by the Biden administration as a political maneuver, it is unlikely that these senseless deaths would have occurred. Democrats can try to frame these tragedies as an issue of abortion access in red states, but the reality is that these women had access to medicine that the Democrats told them was entirely safe, and the lack of timely medical attention in their circumstances is a result of malpractice. We have diverted so far from the Democrats' original goal of, quote, safe, legal, and rare. Now it is somehow acceptable to have abortion-on-demand campers parked outside the Democrat National Convention and to permit the use of chemical abortion pills with no medical oversight. Democrats can call this hearing what they want, but at the end of the day, it's Democrat policies putting women at risk and taking lives, all under these false pretenses of women's rights and health care. Dr. Francis, you are a medical doctor, you're an obstetrician and gynecologist. Can you explain how Georgia's abortion law was not relevant in the cases of Amber Thurman or Candy Miller because these laws did not apply to the care they needed?
Absolutely. So Georgia law clearly did not apply in either case, especially that of Amber Thurman. When she presented to the hospital, per the reports that we have, her unborn children had already passed away, which means that Georgia law explicitly would not have applied. But even if there were still heartbeats when she had presented to the hospital, based on the reports, the symptoms that she presented with, any first-year OB resident could have made a diagnosis of a septic incomplete abortion, which is a life-threatening emergency, which Georgia law clearly has exceptions for. Georgia law does not prevent a DNC in any of those situations, and her doctors should have intervened immediately. And Candy Miller as well. Had she presented to the hospital, had she not been afraid because of the lies that she had heard that she might be prosecuted if she showed up to her hospital with complications after a chemical abortion, because she had retained tissue and presumably did not have a living unborn child anymore, she could have received treatment immediately as well. It was not Georgia's law that led to their deaths. It was the complications of the abortion drugs.
I have a follow-up question. This is my final question. Dr. Francis, do physicians know, as a physician yourself, as a medical doctor, do physicians know how to practice with, quote, reasonable medical judgment and what that means?
Absolutely. We do each and every day when we think about, the potential of a malpractice suit, and as related to abortion, every state law before Dobbs that had some sort of limit, like in Indiana, we had a 20-week limit, but there were exceptions beyond that, and doctors had to use their reasonable medical judgment. It's the exact same legal standard that we practiced under before Dobbs applies now as well.
Time my colleagues expired. I'm going to go to Senator Tillis, but I just got to set the record straight. on a couple of points. Number one, there was discussion about the Biden administration being the problem. The law that we want to see carried out, the EMTALA law, is almost 40 years old. And the difference of opinion is my colleagues on the other side really don't want it to be carried out. We do, in order to make sure that women have access to health care. So that's number one. Number two, there was discussion of mifepristone. The science shows that any adverse reaction occurs in less than 0.5% of medication abortions in the United States, not even a full percentage point. So that's the facts with respect to this issue. Senator Tillis.
Thank you, Mr. Chairman.
Here, 1 second. We may have we'll have Senator Tillis next, and we're getting close to being done. Senator Tillis, I thank my colleague from South Dakota.
We're in the political silly season now, where we have hearings like the one we're having today that is titled "Chaos and Control: How Trump Criminalized Women's Health." And we're talking about things as if Trump went to Alabama and passed a law in Alabama, and Trump went to Louisiana and passed a law in Louisiana. Nothing can be further from the truth. So let's just at least level set and not put words in President Trump's mouth. President Trump said, like Ronald Reagan, I believe in the exceptions, rape, incest, and life of the mother, at the debate back in June. These are President Trump's words. I know people are trying to put words in his mouth. That's what he said. Now, then we have some people here, again, political silly season. I know some of my colleagues have referenced it on the other side of the aisle, Project 2025. I've never read that document, but apparently President Trump has to own something that a third-party think tank did on life. Also, not true. I kind of am old-fashioned. I think that the Republican Party platform that was adopted in Wisconsin this year is probably the best indication of what Republicans are running on. The platform says we will oppose late-term abortion while supporting mothers and policies that advance prenatal care, access to birth control, and in vitro fertilization treatment. That's the Republican Party platform, not words that people want to put in our mouths from third parties. It's the political silly season. One of the reasons my colleagues want to make it seem like we're so extreme here, number one, this is a states' rights issue. And in my opinion, some states have gotten it wrong, and they're probably going to suffer political consequences at some point in the future. My state, I think, got it right. Why does nobody talking about an abortion law, an access to abortion law that was passed this year in North Carolina? Because we know the majority of people in North Carolina support the bill. 12 months with 12 weeks with reasonable exceptions. Why wasn't that a news story here? Why didn't the Democrats mention it? Because they all know the same thing. The majority of the American people think there should be reasonable limits to access to abortion. But obviously, not leaving someone out to die. Physicians having an obligation to provide care. We support that. This is the political silly season. I can't imagine anybody in the Republican conference of the U.S. Senate who embrace some of these extreme positions that my colleagues would like to suggest that we support. I was Speaker of the House in North Carolina. We passed 4 pro-life bills. I am a U.S. Senator who opposed someone who wanted unrestricted access to abortion today because we reflected the wishes and the desires of the people of North Carolina. A couple of states get it wrong on my side of the aisle. Tough for them. They lose elections, replace them, change the law. This is a states' rights issue that most states are getting right. But now I want to talk about what the Democrats really don't want to talk about. And it's their extreme position that, quite honestly, I'm not going to put anyone on the dais who's a majority witness. But I've got to be clear. In May and February of 2022, there was a vote on the Senate floor that they say is a reasonable position on access to abortion. I am not an attorney, but I just tried to confirm this with my staff, and I think what I'm about to say is true. And if it's not, Ms. Hacker, I'd like for you to correct me. 2 times on the Senate floor, Chuck Schumer made a political statement, political silly season again, and the statement was that they wanted the Women's Health Protection Act to be passed. The Women's Health Protection Act was going to compel a religious institution to potentially, if they win the argument on the smart language that they put in, to provide, to exempt the Hyde Amendment, if they could get shop a lawsuit and say that not having federal taxpayer dollars fund an abortion is unreasonable, preventing unreasonable access or restrictions to care. They voted twice in 2022, including, and a number of people who weren't here at that time have co-sponsored a bill that mandates access to an abortion, up to and including potentially a religious institution, to perform an abortion without the consent of parents, and if I'm not mistaken, without a doctor present, potentially a physician's assistant. Am I correct in that assessment of that bill, Ms. Hacker?
Senator, thank you. I have not done a deep analysis of that bill, but it does permit non-physicians to perform abortions, and it also, I believe,
allows minors to do it without the advice of their parents and could be done in the late term. That is an extreme position that I guarantee you the majority of the American people reject. Thank you, Mr. Chair.
Okay, it's now indisputable fact that it will be Senator Thune and Senator Langford.
Thank you, Mr. Chairman. Well, and that bill also, my colleague from North Carolina allowed for taxpayers to pay for those abortions, a position that has, both sides have agreed shouldn't happen going back to the 1980s. That's been a commonly held position. This is, ladies and gentlemen, this is political theater. We know what it is. We're 5 weeks out from an election and an issue which is being used offensively by our colleagues on the other side in a way that they think will help them politically in this November's election. That's all this is, nothing more, nothing less, nothing else. And Democrats want you to think today that they're the party that supports and acts in the best interest of women. This hearing has nothing to do with women and babies. It has everything to do with politics. And I would tell you, and I have 2 daughters and 3 granddaughters. My wife and my youngest daughter, who's 34, have both been president of an organization called Teddy Bear Den, which is an organization in South Dakota, not a government organization, but one that supports single moms through their pregnancies and then helps care for their babies after they're born. You know, that to me is what we ought to be about. It's about compassion and caring and taking care of moms and babies. But Democrats often want to pick and choose which babies get supported. And sometimes abortions don't go as planned and the baby miraculously survives. These babies deserve to receive medical care just like any other baby that's born into this world. And Democrats have, of course, to argue that this doesn't happen, but the CDC estimates that between 23 and 2014, at least 143 babies died after being born alive during abortions, and that doesn't count the babies that actually survived. It's a basic standard of decency to protect these babies. Yet Democrats year after year have voted against a bill that I lead with Senator Langford that would ensure babies who survive an attempted abortion receive the same care as any other newborn. Dr. Francis, could you tell us a little bit more about how a baby may survive an abortion, and shouldn't this baby be given the same opportunity as any other baby to receive medical care?
Absolutely. So as you said, Senator Thune, we know that babies are born alive after a quote-unquote failed abortion. In fact, there was an abortionist in the past who called it the dreaded complication of an abortion when a baby is actually born alive. And we have data from several states saying that even in recent years, there have been multiple babies that have been born alive after an abortion. I don't think that a child's right to receive appropriate medical care should depend on whether or not that child was born as a result of an abortion or born as a result of a normal delivery. Those children deserve the exact same level of medical care that we would provide for any child. And we know it is documented in state data that there are children that are being born alive after failed abortions who are not being given any medical care and are being left to die. We should agree, again, on both sides of this issue that those children deserve to have appropriate medical care when they are born alive.
Yeah, and that is an incredibly defending a position that would allow that to happen after a baby is born is an indefensible position, and one that shouldn't be a partisan issue, honestly.
And I hope at some point that my Democrat colleagues will find their way to support that legislation. They've said this morning, some of my Democrat colleagues, that this hearing is intended to examine the supposed attacks on women's health. However, they fail to discuss how abortion can impact a woman's physical and mental health. As I said earlier, Republicans support women throughout their lives, which is why we have supported funding for the over 3,000 pregnancy resource centers throughout the United States, which are dedicated to providing support for moms and babies. South Dakota, these centers have been a lifeline to pregnant women, providing medical exams, food, diapers, along with education and help accessing other resources a woman and her child need. Democrats have said they don't believe there's enough support for pregnant women, but they also want to defund these centers. Dr. Francis, could you tell us a little bit more about the effects of an abortion on a woman's health? And in your experience, how have you seen these pregnancy resource centers support and benefit women?
Absolutely. So to answer your first question, we know that induced abortion carries significant risks to women's both physical and mental health. Over 160 studies show that induced abortion through surgery increases a woman's risk of preterm birth and future pregnancies. Not only does that threaten the health of her future children, but we also know that women with a history of preterm birth have a higher rate of cardiovascular disease and stroke later in life, so it's impacting their long-term health. We also know that women have a 7 times increased risk of suicide after induced abortion. This is even higher in women with pre-existing mental health disease. These are risks, again, that women should be made aware of before they make the choice to have an abortion. To your second question about pregnancy centers, just yesterday I had the privilege and honor of touring a pregnancy center in Lexington, Kentucky, and they told me about the story of a family, a couple that they had helped who came in with an unplanned pregnancy, and after talking to them decided to continue their pregnancy. Not only did they help them with material needs, but now that couple is married, they both finished their education, and they are doing amazing. That pregnancy center didn't just help them through their pregnancy, it helped elevate them out of the circumstances they found themselves in and helped them to be successful. That's what pregnancy centers are doing. They're doing it for no reimbursement, no profit to themselves. They're doing it because they not only care about those babies, but they care about the moms and the dads, and they're coming alongside of them.
Time of my colleagues expired. Senator Langford.
Thank you. Thanks for staying so long in this testimony and the conversation today on this. This is extremely important to be able to have a dialogue and try to get facts out there, because there's been a tremendous amount of rhetoric. And I've even heard conversations today about misinformation or rhetoric or intellectual honesty and all these things that have come out in the dialogue today. And I want to be able to help bring some things together from hearing the testimony from the entire day on this. Ms. Hackler, just to clarify on this, are there any states where women face prosecution for having an abortion?
No.
Are there any states that criminalize miscarriage?
No.
Or that care for a miscarriage?
No.
Are there any states that criminalize removing an ectopic pregnancy?
No.
Are there any states that prohibit life-saving care for the mother?
No.
Are there any states where women have to be actively dying for a doctor to be able to act for her care?
No.
There's been a lot of rhetoric in this that I'm concerned pushes people away from getting access to health care. Vice President Harris, in a speech recently, said that women were being arrested and facing prosecution for experiencing miscarriages. Ms. Hackler, do you know of a single instance where a woman has been arrested for having a miscarriage or getting health care for that?
No, treatment for miscarriage is allowed under the law, and there have been instances where I think that one example of that that's been pointed to is misleading, because the woman, I think she was in Ohio, the charges against her were not abortion related, and so it's misleading to use that as an example.
It's not only misleading, but it scares women away from getting access to health care, and it leads women to not go get health care treatment when they desperately need it. Dr. Francis, there's been a lot of conversation about chemical abortions. Obviously, we have recent cases of Candy Miller dying from a chemical abortion. FDA has changed the rules of late to be able to say, don't give us information about consequences, don't even report that, don't turn it in. You don't have to get to a doctor to be able to get access to chemical abortions. There's been lots of conversations I've heard from my Democrat colleagues saying chemical abortions are as safe as Tylenol. Can you tell me a little bit more about chemical abortions?
Absolutely, thank you. And I would like to correct the record in saying that complications related to these drugs are rare. We know per the FDA's own data that 1 in 25 women who take these drugs will end up going to the emergency room. And a recent study that came out actually showed that emergency room visits related to chemical abortions were significantly more likely to have a severe diagnosis code associated with them than were visits after surgical abortion or even visits after a live birth. So women are going to the emergency room for severe complications like infection. You know, back in 2006, Congress did an investigation actually after several women died from the same kind of sepsis after taking these drugs. Congress has known about this since 2006. It has continued ever since. And that is what Amber Thurman died from, and it's what Alana Dixon in Nevada died from, infection related to taking these abortion drugs. Incomplete abortion, where all of the tissue from all of the fetal tissue and placental tissue don't pass after taking these drugs, occurs in 5 to 10% of women. That may sound like a small number, but when you look at the number of chemical abortions that are done in this country every year, that's a significant number of women that are experiencing this complication. These are not as safe as Tylenol. Tylenol complications occur when women or when anyone overdoses on Tylenol and then goes to the emergency room. These complications are occurring when women take these drugs per the FDA, how they are indicated, and they're going to the emergency room at a rate of 1 in 25. These are not safe drugs, and women deserve to have accurate information about that.
Dr. Francis, FDA has changed the rules where you don't have to have access to a doctor or have a doctor review, examine you, anything on that to be able to get the drugs to you. What are the risks there, receiving just chemical abortion drugs in the mail and not having a doctor do any kind of examination leading up to that?
This is extremely risky and should actually be considered medical malpractice. Without a woman seeing a physician or another medical professional, we can't confirm how far along in her pregnancy she is. We know, according to even the FDA's own data, that the farther along in pregnancy a woman is when she takes these drugs, the higher the risk of complications. And the American College of OBGYN says that up to 40% of women will be wrong about how far along they are in their pregnancy based on last menstrual period alone, that ultrasound should be used to date a pregnancy. So we can't know how far along she is in her pregnancy. We can't know that she does not have an ectopic pregnancy, which are very common and are life-threatening. We also can't screen her for Rh disease to know if she's Rh negative and needs a medication called Rogam to prevent complications in future pregnancies. All of these things could be done if a woman was being seen in person by a physician or another medical professional prior to receiving these drugs.
But the rules have changed on that. That's no longer required.
Right.
Okay.
Is my colleague done? Yes. On this question of whether anybody has been arrested for having a miscarriage, I believe it was you, Ms. Hacker, who said nobody has been arrested. Indications are that that's incorrect. Amari Marsh in South Carolina was charged with murder, homicide, about child abuse 3 months after losing her pregnancy in 2023. A grand jury cleared her of that charge in August. And I'm going to make sure the record is clear on that point. Senator Whitehouse.
Thanks very much. I've heard colleagues say that today's hearing is all about political theater. I doubt they would say that if they had heard the testimony in the Judiciary Subcommittee of Lauren Miller, a woman from Texas who was carrying twins, and one of her twins was not going to survive the pregnancy. And the standard of care would be to remove the twin who would die to protect the chances of the surviving twin, and also to protect her health and her ability to have further children in the future. And that seemed like a very reasonable choice for that family to make. But when she tried to make that choice, she ran into the circumstance that her doctors had to walk away from her had to essentially abandon her, to say to her, we are not allowed to make the recommendations that you need in the circumstance that you are in. We cannot give you proper care because of the danger that we feel that we will be prosecuted if we give you the advice that is the modern standard of care for this situation. What you're going to have to do is go someplace else, where you're out from under the shadow of the Texas legislature and can get the care that you need pursuant to modern medical standards. And so she did. And she flew to Colorado and has since returned home. Her son, the twin that was healthy, is alive and well. She is doing well. But it was hard to hear her talk about moments in that experience, like the moment when she felt the trust between her and her doctors collapse. When you're in a difficult medical situation, you really want to be able to trust your doctor. And when your doctor says, nope, I'll use the phrase, the nitwits in the legislature are actually now controlling my decision instead of those of us who are trained in this kind of a procedure, and you can't trust me any longer to give you the right advice because I think I'll get in trouble with the law if I give you the right advice. That's a very daunting loss of confidence and a very sudden shock and horror for Lauren to have had to go through. The second was waiting in the line for the flight to Colorado with the worry in the back of her mind that somebody was going to pull her out of line and say, no, you don't get to go. We're going to take that choice away from you. Those are moments that no woman in this situation should ever have to have. We disagree, obviously, across the aisle on the general question of whose choice should this be? Should it be the family's decision? Or should it be the state legislature's decision? Or should it be Congress's decision if we choose to do a national ban on abortion, as many Republicans recommend? For me, that's a very easy question. That's a family and doctor decision. But when you then get to the situation where it is the doctors who are unable to provide treatment to the standard of care that they've been trained to because of the shadow of fear of prosecution, you have now intruded into something that I think is very, 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 very wrong. I hear it from my OBGYN doctors in Rhode Island because OBGYN doctors talk to each other about these situations and about what they're forced to do. And they are horrified at what their colleagues in these other states have to go through. An entire medical career is built around your duty and your obligation to give to your patients the very best care that you can, consistent with the standard of care. And when a bunch of bozos in a state legislature butt into that relationship and say, no, you got to do it our way. We don't care about your situation. We don't care about your danger. Here's the law, and if you don't go along with it, you're going to get prosecuted. That is a violation of something that is very, very special. So I am delighted that we held this hearing, and I just want to push back on the notion that this is political theater, because I'll tell you, for those women in that situation, for those OBGYNs in that situation, this is not political theater. This is a wrong that is being done to them right now as a result of very bad political decision-making, in particular, political decision-making by certain justices on the Supreme Court.
Thank you, Senator Whitehouse. Senator Barrasso, I believe, will be our last witness, or excuse me, our last questioner.
Well, thank you, Mr. Chairman. And, you know, for years we've worked together in good faith. See Senator Whitehouse talking about political theater. I read the title of this, Chaos and Control. It says how Trump criminalized women's health care. Sounds like a lot of political theater to me, Mr. Chairman. Fairly disappointed. Nearly 2 decades of working together. I've never seen you use the position as chair of a committee to put politics over people. I think it's if your intention for today's hearing is to discuss women's health, then I would expect you would have chosen a title for today's hearing that didn't include a presidential candidate's name. Despite your intention to pull focus away from the real issue of women's health, and I've been a doctor, practiced for 24 years, I'd like to highlight a disease affecting women that is personal to me. The cancer, leading cause of death for women. Last year, 60,000 women died from lung cancer, 42,000 women died from breast cancer, 24,000 women died from pancreatic cancer. My wife died earlier this year of glioblastoma brain tumor. Nearly 300,000 women in total will lose their lives to cancer this year. Yet today, instead of focusing on legislation like Ranking Member Crapo and Senator Bennett's bipartisan Multi-Cancer Early Detection Screening Coverage Act, an act that would actually help Medicare beneficiaries access the most up-to-date cancer screening available. And with cancer, the outcome is largely based on how early it is caught and how early treatment begins. So when I compare our system in the United States to the British healthcare system, free in Britain in many ways, but not so good for 5 years survival after you've been diagnosed with cancer compared to the United States. Not that our doctors are smarter than theirs, it's that people actually get the care much sooner here in the United States than the misery and the meltdown that is happening in the British healthcare system. So the cancer outcome is largely based on how early it is detected and treatment begins. But instead of focusing on legislation that has been supported by nearly every member of this committee, you have chosen to focus on a topic that divides our committee, and we've heard the comments on both sides of the aisle today. So, Chairman, will you commit to focusing this committee's efforts on policies impacting the health of women across America instead of fear-mongering? I mean, I'm not going to ask you a question. I'm going to ask the panel a question. But that's what we ought to be doing here today in an attempt to actually solve the American public's concerns with cancer as opposed to focusing on an upcoming election. Because despite the Biden administration and the best efforts by the Democrats on this committee, America still knows that women's health does not just mean abortion. It means a lot of things. And it's my hope we can improve the health outcomes of women by taking a complete and a holistic look at women's health and their unique needs. So, Dr. Francis, as a fellow healthcare professional, I know patient safety has always been and will be your top priority, which is why I can imagine the recent deaths of Amber Thurman, Candy Miller of Georgia are very troubling to both of us. Amber and Candy died shortly after taking the abortion-inducing drug. In the case of Candy, she ordered the drug online. Any healthcare provider would tell you that all the medications have known as well as unknown side effects, especially when they're taken along with other medications, other things that maybe aren't even prescriptions. And if a patient has a chronic condition, it can also impact that. And, you know, Candy, who has lupus, diabetes, hypertension. So, you know, Dr. Francis, as a fellow, as a pro-life physician, can you please speak to the risks that women face in taking abortion-inducing drugs, which is not under the supervision of a physician, and specifically the risks of ordering this medicine online?
Absolutely. Well, thank you, Senator, for that question. As you said, I care deeply about my patients, about them receiving safe and excellent medical care. And I think that removing any kind of medical professional, but especially a physician, from the equation anytime a patient is going to receive medication is very dangerous, but especially when we're talking about drugs that have the kind of complications associated with them that mifepristone and misoprostol for induced abortion do. Again, no matter where somebody stands on the issue of abortion, we should all desire for women to receive excellent health care, to receive fully informed consent, to be adequately screened, and receive individualized informed consent, which you know, as a physician, you know that means that taking into account all the specifics about that person that's sitting in front of you. You know, a comment was made about breaking the trust of the physician-patient relationship. Where's the physician-patient relationship when a woman goes on a website and order these drugs? It's not there.
Thank you, Mr. Chairman. My time has expired.
I thank my colleague. In wrapping up, I want to be clear. This hearing is about women's health care. And it's about how women aren't able to get health care, as Ms. Joshua described very specifically. And we asked about it in detail and how others can't get the kind of health services that Ms. Joshua was talking about. So make no mistake about it. This is about women's health care, and it's about a federal law, EMTALA, that's almost 40 years old, that ensures women have access to those services. And I just want to be clear that we're going to stay at it until women can get those health care services that are spelled out in this nearly 40-year law. And as you could tell today, not everybody here agrees with me, but federal law does. And with that, I want to say that we'll keep the record open for my colleagues to ask their questions, typically for a few days. And with that, the committee is adjourned, and I thank our guests.